So imagine this. You've got an agreement with your HOA, right? It's been solid, totally unchanged for 15 years. And then one day, boom, a letter shows up, and that whole deal is just gone. Today, we're going to unpack a crazy legal drama where a 15-year precedent got completely shattered by one little rule nobody remembered.
Okay, so this is the plea that kicked the whole thing off. This is straight from the homeowner, Loraine Brokaw. And look, she wasn't asking for some brand new discount or anything. She was just saying, hey, can we please stick to the deal we've had for, over a decade?
So for 15 years, this was the deal, 150%. Now, what does that even mean? Well, it was a special rate, 100% for her main property, plus 50%, just half the fee, for the lot right next to it that her house was also built on. It was a unique solution because, well, she had a pretty unique home.
And then bam! 2017, a letter shows up demanding this, 200%. And we're not talking about a tiny little fee increase here. This meant she was now being charged a full 100% for each lot. It basically doubled the fee on that second piece of property out of nowhere. So you can imagine, for Brokaw, this just felt totally out of left field. I mean, after 15 years of paying the same rate, why this huge hike all of a sudden? This letter, this was the first shot fired in what turned into a long, drawn-out legal fight with her HOA.
Okay, so let's back up a bit. Where did this special 150% rate even come from? I mean, this wasn't some casual handshake agreement, nope. This was an official, on-the-books decision made by a previous HOA board. This timeline really lays it all out. So check it out. Back in 2003, the Brokaws build their house, and it actually stretches across 2 different lots. The board at the time sees this, recognizes its unique situation, and they officially vote to create this special 150% rate just for them. For the next 14 years, everything's fine. That's the deal. But then 2017 rolls around, a new board takes over, and poof, they cancel it. Just like that.
And let's be super clear here. This was all totally legit. The original decision back in '03, it was documented in the official meeting minutes. They even sent Brokaw a letter confirming it. It was an established, totally reliable part of how they did things. Until one day, it just wasn't.
So, this all leads to a hearing, where both sides finally get to lay out their arguments. And this is where things get really interesting, because this wasn't just about the money. It was about precedent, about what's fair, and really about how much power an HOA board actually has.
And here it is, the heart of the conflict. Brokaw's side is basically saying, hey, 15 years of doing something one way makes it a binding agreement. You can't just change the rules now. The HOA, on the other hand, is arguing that the old board just flat out made a mistake and that they, the new board, have a duty to fix it. So it all comes down to this one huge question. Does the way we've always done it beat what's actually written in the rulebook?
So how do you even begin to solve a puzzle like that? Well, the judge had to go way back. Not to the 2003 meeting notes, but to the source. We're talking about the community's original foundational documents, the ones written before a single house was even built there.
And what are those documents? They're the CC&Rs. The best way to think about these is like the Constitution for the neighborhood. When you buy a house in an HOA, you're basically signing a contract agreeing to follow these rules. And here's the kicker, they are the ultimate authority. They trump board decisions, they trump precedent, they trump everything.
And deep inside that Constitution, the judge found it, the smoking gun. It was just one sentence, pulled right from the bylaws, but it changed absolutely everything. It said that the association must assess all similar lots at a uniform rate. Uniform. There was literally no wiggle room in the legal language for a special one-off deal.
Okay, so with the facts on the table and the rule book right there in front of him, the judge had everything he needed. It was time to make a final call. That 15-year tradition was about to have a head-on collision with the cold, hard letter of the law.
And the verdict? Petition denied. The decision did not go Loraine Brokaw's way. The judge sided with the HOA, and just like that, the 15-year-old deal was officially over.
The judge's reasoning was actually pretty straightforward, and it came down to 3 main things. First, the contract is king. The CC&Rs are the law of the land here, and they overrule any other agreement. Second, those rules demand uniformity. Period. No special exceptions allowed. And third, and this is crucial, because Brokaw legally owned 2 separate lots, the HOA wasn't just allowed to charge her for both, they were required to. So you see, the new board wasn't actually making a new rule. They were just for the first time enforcing the original one.
So let's just let that sink in. A 15-year-old agreement totally wiped out by a couple lines of text in a document from way back in 1978. So what does this case from Arizona mean for the millions of us who live in HOAs all over the country?
Well, the biggest takeaway is this: the written word wins every time. It doesn't matter how long a special deal has been in place. If it goes against those official documents, it can be thrown out. That whole argument of, but we've always done it this way, turns out that's not a legal defense. A new board can come in, read the fine print, and just completely erase years of tradition. At the end of the day, your rights are defined by the contract you signed, not by what's considered normal.
And that right there is why this case matters so much, way beyond just Arizona. It leaves all of us with a really important question to think about. Do you actually know what's in your community's governing documents? I mean, really know? Could there be some forgotten rule buried in a dusty binder somewhere, just waiting to turn your world upside down?